Hello everyone, my name is Rachel Alsoyco, CRI 415, Crimpros, code 1084, 7:30 to 8:30 p.m. Rule 110. Prosecution of offenses. Section 1. Institution of criminal action. Criminal action shall be instituted as follows. For offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112. By filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. For all other offenses, by filing the complaint or information directly with the municipal trial courts and municipal circuit trial courts, or the complaint with the office of the prosecutor in Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. Section 2. The complaint or information shall be in writing in the name of the people of the Philippines and against all persons who appear to be responsible for the offense involved. Section 3. Complaint define complaint is a sworn written statement charging a person with the offense subscribed by the offended party, any peace officer or other public officer charged with the offense enforcement of the law violated. Section 4. Information defined. An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Section 5. Who must prosecute criminal action? All criminal action all criminal actions commenced by a complaint or information shall be prosecuted under the direction of the control of the prosecutor. Section 6. Sufficiency of complaint or information. A complaint or information is sufficient if it states the name of the accused, the designation of the offense given by the statute, the act of omission, complaint of us constituting the offense, the name of the offended party, the approximate date of the commission of the offense, and the place where the offense was committed. Section 7. Name of the accused. The complaint or information must state the name and surname of the accused or any application or surname of the accused or any appellation or nickname by which he has been or known. Section 8. Designation of the offense. The complaint or information shall state the designation of the offense given by the statute over the acts or omission constituting the offense and specify its qualifying and aggravating circumstances if there is no designation of the offense. Reference shall be made the section or subsection of the statute punishing it. Section 9. Cause of the accusation, the acts or omission complained of as constituting the offense, and the qualifying and aggravating circumstances must be stated in ordinary and language and not necessarily in the language used in the statute, but in terms sufficient to enable a person of common understanding to know what offense is being charged, as well as its qualifying and aggravating circumstances, and for the court to pronounce judgment. Section 10. Place commission of the offense. The complaint or information is sufficient if it can be understood from the allegation that the offense was committed or some of the essential ingredients occurred at some place within the jurisdiction of the court, unless the particular place where it was committed constitute an essential statement of the offense or it's necessary for the identification. Rule 111. Prosecution of civil action. Section 1. Institution of criminal and civil action. When a criminal action to instituted the civil action for the recovery of civil liability arising from the offense charge shall be deemed instituted with the criminal action unless the offended party waives the civil action, reserve the right to institute it separately or institute the civil action prior to the criminal action. Section 2. When separate civil action is suspended after the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until final judgment has been entered in the criminal action. Section 3. When civil action may proceed independently in the cases provided for in Articles 32, 33, 34, and 2176 of the Civil Code of the Philippines, the independent civil action may be brought by the offended party. It shall be proceed independently of the criminal action and shall require only a preponderance of the evidence. Section 4. Effect of death and civil action. The death of the accused after arraignment and during the pendency of the criminal action shall be extinguish the civil liability arising from the delect. Section 6 Section 5, judgment in civil action, not a bar. A final judgment rendered in a civil action absolving the defendant from civil liability is not a liar. From the civil liability is not a bar to a criminal action against the defendant from the same act or omission subject of the civil action. Section 6, suspension by reason of prejudicial question. A petition for suspension of the criminal action based upon the pendency of prejudicial question in a civil action may be filed in the office of the prosecutor of the court conducting the preliminary investigation. Section 7, elements of prejudicial question. The elements of prejudicial question are the previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequently criminal action, and resolution of such issue determines whether or not the criminal action may proceed.